Hi, I'm Emily, and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, how will I know if my child is eligible for special education services, and who refers my child to special education?
Connecticut law defines a child requiring special education as a child who meets the criteria for eligibility for special education pursuant to the Individuals with Disabilities Education Act, otherwise known as IDEA. Meanwhile, New York law defines a child with a disability or a student with a disability as a person under the age of 21 who is entitled to attend public school and who, because of mental, physical, or emotional reasons, can only receive appropriate educational opportunities from a program of special education. Special education services eligibility under the IDEA requires that your child be between the ages of 3 and 21 years old. Both Connecticut and New York school districts are obligated to provide special education and related services to children ages 5 years of age or older until the earlier of either high school graduation or the end of the school year in which your child turns 21. In addition, a child must have a defined disability as determined by the IDEA. For example, some of the defined disabilities under the IDEA are autism, emotional disturbance, intellectual disability, other health impairments including ADD, and a specific learning disability. If a formal evaluation determines that your child is impaired by an IDEA-defined disability or disabilities, and the disability is adversely affecting your child's educational performance, a specific educational program must be developed to meet his or her unique educational needs. This is known as an Individualized Education Program, or IEP. Children requiring special education services in Connecticut include not only children with disabilities, but also those who are found to be especially gifted and talented. The statute in Connecticut states, a child requiring special education means any exceptional child who has extraordinary learning ability or outstanding talent in the creative arts, the development of which requires programs or services beyond the level of those ordinarily provided in regular school programs, but which may be provided through special education as part of the public school program. While the gifted and talented identification and evaluation of students is mandatory, the provision of services for identified students is not required and is left to the discretion of the specific school district. Although gifted and talented children may be offered special education in the state of Connecticut, it is not a requirement. Meanwhile, in New York, students who are entering public school for the first time must be screened to evaluate whether or not they are gifted. The screening must include an assessment of language development and must be conducted in the student's native language. If the student is found to be possibly gifted, the results of the screening must be reported to the school superintendent and to the student's parents or guardian. If the student is referred for further consideration to a gifted program, the school must inform the parent and seek approval. As in Connecticut, there is no requirement in New York for gifted children to be offered a special education program. Connecticut requires each school district to reach out and identify children from birth to 21 years of age who may be eligible for special education services. The IDEA covers all children with disabilities residing in the state, including those who are homeless or wards of the state, and children with disabilities attending private school, irrespective of the severity of their disability. It is the obligation of the school district to identify children in need of special education from birth on. This duty is called child find. After finding a child with a disability, the school district must initiate an evaluation of that child to fulfill their duty under the IDEA. A referral to special education is the first step in determining whether a child is entitled to receive special education and related services in Connecticut. The referral takes the form of a written request that a child be evaluated if he or she is suspected of having a disability and may be in need of special education and related services. If your child is over the age of 3 and you believe he or she may have a disability, as a parent, you may submit a written request to the Director of Special Education of your school district. If someone other than a child's parent refers a child to special education, such as a teacher or school administrator, the parent must receive notice of such referral. In Connecticut, those who may make a referral for an evaluation are the student, provided they're 18 years of age or older, a parent or a guardian, the state educational agency, the local educational agency, or individuals from other agencies, including physicians or social workers, having parental permission to make a referral. In New York, students suspected of having a disability are referred to a multidisciplinary team called the Committee on Special Education, or CSE, or the Committee on Preschool Special Education. The committee then arranges for an evaluation of the student's abilities and needs, and based on evaluation results, the committee decides if the student is eligible to receive special education services and programs. If you have any questions as to whether your child may be eligible to receive special education services, I'd be happy to discuss your matter. Thank you.